Kailash Chandra, transcription number 404, back at 57 words per minute. Be ready, 5 seconds to go. Now, in this bill, it has been made clear that so far as these acting judges and additional judges are concerned, their service as such will be counted for the purpose of pension only if they are subsequently made permanent judges. Otherwise, for example, if no such provision was made, then their service for the purpose of pension would be counted only from the time they are made permanent. But here it has been made clear that in case they are made permanent, their previous service as an acting or additional judge will also be taken into account for the purpose of their pension. So far as leave is concerned, whatever leave they would be entitled to in view of the period of service that they have put in as acting judge or additional judge will be taken into account, and under the scheme of leave as mentioned in the Act of 1954, they would be entitled to a period or periods of leave as then laid down. Then, sir, after this, a very important question arose. So far as the unexpired leave was concerned, as also the question of the pensions of the former part B state high court judges who were continued as judges in the new high courts that were established on the reorganization of states. We had some high courts, as you are aware, in Part B states. When under the Constitution. These Part B states themselves ceased to be as such, and they were placed in the reorganized states of India. Naturally, the high courts in Part B states also disappeared. So far as these judges were concerned, a very large number of them were ultimately appointed as judges in the new high courts under the States Reorganization Act, and naturally a question arose as to what is to be done so far as the period of service that they had previously put in the Part B state high courts was concerned. A question arose as to whether the period of service that they had put in as a high court judge, including in some cases as chief justice, should or should not be taken into account, or whether some other formula should be introduced by which a particular period and not the whole period should be taken into account. In this connection, two questions arise. One is about leave. If, for example, they were entitled to certain periods of leave, and then by the time the new high courts came into existence, they continued in effect to be high court judges. What was to happen to the unexpired leave period?